That's, yes. And when you say brief, what did you have in mind?
2 to 3 minutes each.
Sure, that sounds fine. So we're going to start with a brief statement from a couple of the plaintiffs, and then I'll ask Mr. Murphy to go first. So, who would ever like to proceed? Mr. Buffins, perhaps?
Your Honor,
Yes.
I'm sorry. I had a hard time hearing you when you were orienting us for our arguments. Would you mind just repeating where you'd like us to focus?
Sure. I'm going to move up a little bit to be closer to the microphone. At any point in the proceeding, if anyone can't hear me or somebody else, please just wait, because we don't want to have to do everything twice. I suggested that when I first read the papers, it seems to me an important issue is to distinguish this plaintiff's case from the Harvard Climate case, because it's relatively recent. I think plaintiffs have done that in their opposition papers, and so I suggested that all the defendants should probably focus there rather than the first round of arguments, which I'll just say the plaintiffs have sought to distinguish their case. So let's focus on that. That was my only suggestion. And I said I'll hear from Mr. Murphy for the Harvard defendants, and then you, Mr. Rowe, and then from the plaintiffs in connection with all of those issues, rather than dividing it up by defendants. Okay?
Thank you.
We'll have one more person in the waiting room coming in. All right. So I just said the plaintiffs I'd be happy to hear from at the outset. And I'm actually going to read into what Ms. Nathanson said. This is a little bit different than the legal argument. This is about your reasons for being here, so I'm happy to hear you. So go ahead.
Thank you, Your Honor. Your Honor, since chattel slavery, Black people have had to explore every way and every avenue to get free. The court, of course, has been one of those avenues. And that is why I, Jared Martin Drake, son of Linda and MacArthur, grandson of Marie and Bertha, a descendant of survivors of the transatlantic slave trade, of plantations in the Mississippi Delta, of Jim Crow and Jane Crow, of redlining, of the prison industrial complex, am here before this court today. I am here this afternoon along with my fellow plaintiffs in the spirit of a freedom suit. In the antebellum era, enslaved people filed lawsuits in protest of their enslavement. In the course of my scholarly research, one case always sticks out. In the late 1850s, 17 people enslaved in Princess Anne County, Virginia, filed a freedom suit claiming that the man who had claimed ownership of them dictated that they be emancipated upon his passing. However, after the enslaver's death, his executor demanded they still be held in bondage. And so these courageous 17 souls went to the county circuit court to demand, quote, a complete and perfect title to their freedom, end quote. Relief, which in their words would be, quote, just and proper, end quote. The 17 people were soon thereafter granted their perfect title. The defendant Harvard has had its chance to do what is just and proper, but simply refuses. By its own admission, Harvard once profiteered from chattel slavery. We allege that although the particulars may have changed, the blood money remains the same. And so I am here in court, like my foremothers and forefathers before me, to speak my truth, to cleanse the crimson stain off Harvard's endowment, and to get closer to a world where all Black people can finally and fully get a perfect title to our freedom.
All right.
Thank you.
Thank you, Your Honor. My name is Ismail Buffins. I am here both as an eager 1L at the University of Michigan and as an alumnus of Harvard Divinity School. I am the great-great-grandson of Robert Buffins, who was born in bondage in Virginia in the early 1830s. And I'm here to make a living testimony on behalf of my enslaved ancestors and on behalf of the millions incarcerated in the US today. Although it calls itself the land of freedom, the United States has a long history of making gross moral, practical, and legal excuses for the oppression practiced within its dominion. There is a moral excuse for white supremacy in Dred Scott, where a human's life and liberty were grossly denied because of the apparent lawfulness of states' rights and the imperatives of property. During Reconstruction times, African Americans were given the right to vote, practice democracy. As time went on, the practical reality of de facto voter suppression was again excused as not a manifestation of organized race-based policy and terror, but just a procedural problem that was best left to localities to work out. Legally, the 13th Amendment outlawed slavery on the basis of race, or skin color, or geographic origin, but at the same time, the 13th Amendment legalized slavery for those legally deemed to be deserving criminals. Harvard follows the example of the United States. It seeks to excuse its moral complicity with the mass incarceration of Black and Brown Americans through its investments in the prison industrial complex by pointing to its simple fiduciary responsibilities. It seeks to disguise its uninterrupted practice of profiting off bondage by making practical gestures, like the President Faust Slavery and Legacy Statement, which came after a successful student uprising at Harvard Law School to take down the Royal Family Law School shield, which featured 3 bales of wheat in honor of the vicious and cruel slave owning family. By removing the shield, President Faust attempted to rehabilitate the image of Harvard and its close associations with chattel slavery. But by maintaining investments in the prison industrial complex, Harvard continues a profitable relationship with lawful slavery and defends its alleged rights to do so today in court. We are here to address these actions and claims.
All right. Thank you, Mr. Buffett. Thank you, Mr. Drake. All right. So from this point forward, we're probably going to be a little less of an exchange than we'd like.
Excuse me, Your Honor.
Yeah.
Oh, may Plaintiff Alvarez speak as well for 2 minutes?
Oh, I'm sorry. Yes, I thought you said 2, but yes, by all means. And I'll dive back in.
All right. Thank you, Your Honor. My name is Citlali Alvarez Almendariz. I'm a PhD student in the Department of Anthropology at Harvard and also plaintiff. Your Honor, Harvard is a prison profiteer. This is not up for debate. This is a fact. Prisons, whether private or public, are institutions of racial hatred through which the legacy of slavery in the so-called United States, a nation forced and founded on occupied indigenous land, makes itself known and perpetuates itself. It is worth reiterating that we are here today to address the matter of Harvard's investments in the entirety of the prison industrial complex. And by this, we mean all of Harvard's financial investments in those companies and entities that sustain and expand the business of prisons. Like my co-plaintiffs, I come to this case from a deeply personal place. I am party to this suit because as a transgender, undocumented person, a descendant of Otomi people dispossessed of our land and freedom, multiple times imprisoned over generations in so-called Latin America, I know prisons are a violent business. I also note that I'm a beneficiary of deferred action for childhood arrivals. Since 2012, I am subject to paying $500,000 and reporting my criminal history to the Department of Homeland Security every 2 years, and now every year, to live with shaky protection against the deportation force known as Immigration and Customs Enforcement. Given my precarious status before the law, structured and enforced by the threat of deportation and detention, it is abundantly obvious to me. Harvard pretends to care about immigrants, refugees, and asylees when in reality, they invest and profit from their detention and exploitation. Last week, with the horrifying news of forced hysterectomies of Black and Brown women in detention, we are reminded that the practice of human caging is nothing short of genocide.
All right. Thanks for plaintiffs. You set the table. We're going to move on to the issues before the court, which are the legal claims. And so what I was saying before was sometimes in the courtroom we have much more of an exchange. It's a little harder to do that on the Zoom. What I'm going to do is have the speaker view on so I can see quite well the person speaking. Especially if you have any background noise, I'll ask everyone to stay mute because we'll be a little more formulaic than usual. I'm going to hear from Mr. Murphy first. I'll probably have some questions, Mr. Groh, and then Ms. Nathanson or anyone else can sort of tell me what order you all would like to proceed, and I'm going to hear from more than one person. But you can do that when we reach the speak. I've already told you what I'm focused on after reading the briefs, and ready when you are.
Thank you, Your Honor. Your Honor, I'll begin where the court suggested I begin, with the climate justice case, and explain why the differences that these plaintiffs have outlined between their arguments and the ones that were made in climate justice are not meaningful legal distinctions. Climate justice, Your Honor, recognized the long body of Massachusetts case law that says the Massachusetts Attorney General, and only the Massachusetts Attorney General, has standing to bring claims of breach of fiduciary duty or mismanagement of charitable funds by a public charity. Over the years, Your Honor, there really have been two exceptions recognized to that rule. The first is the exception that says where a plaintiff has a property interest or reversionary interest in the property that was donated, that plaintiff has a sufficiently special circumstance or special interest in the public charity to warrant the conclusion that the plaintiff has standing. That's best perhaps represented by the Maffey versus Archbishop of Boston case. The second instance is what you might call the voting rights line of cases, represented by cases like Lopez versus Medford, in which the bylaws of an organization confer very specific voting rights. So in that case, upon payment of membership dues, the plaintiffs were entitled to vote on the election of officers. They were denied that right, and so they were conferred special standing to bring the suits. Those are the only two exceptions that the courts in Massachusetts have ever recognized to the doctrine of exclusive jurisdiction in the Attorney General's office. There is no third category of exceptions, including the ones that the plaintiffs have advanced. Climate justice, for example, recognized that students do not, the status of students does not confer standing. They may be different than other people who are in Cambridge. They certainly can get into Harvard buildings, et cetera, but that doesn't give them the right to sue. The interests which the plaintiffs have advanced here, the fact that they are donors, likewise, does not, under Massachusetts law, long established Massachusetts case law, give them the right to bring this claim. They lack standing. I would cite three cases principally, Your Honor. The 1926 case of Dillaway versus Burton, which goes back nearly 100 years and related to a claim by an heir of one of the founders, the original donors to the Brigham, now the Brigham and Women's Hospital. That plaintiff claimed that the folks who were managing the hospital were mismanaging it and breached their fiduciary duties. She was clearly a donor to the hospital, or she was the heir of a donor to the hospital. But the SJC in 1926 said that was not enough, that the fact that you are a donor does not confer special standing. That decision was reinforced by the SJC again in 1955 in the Ames versus Arnold Arboretum case. There, the plaintiffs recognized that they didn't have any standing, but the SJC left that go without comment, that the mere fact that you were a donor did not confer standing. And most recently, in the line of cases that we're talking about here, there's an appeals court case called Garland from 1999, the Attorney General's office is cited, that reached the very same conclusion. Pardon me, Your Honor, slight technical difficulty here. Hopefully that's better. So I think under the cases, it's very clear that the primary distinction that the plaintiffs here draw between the plaintiffs here and the students in climate justice isn't a meaningful legal distinction, because the cases have already decided, in essence, that being a donor is not sufficient to confer special status. Your Honor,
Let me ask a question on that. Is the will of the donors clause did mean something, gave donors some rights, is it Harvard's position that that would still be a clause, whatever it meant, that only the AG could enforce?
I think, Your Honor, this case would be different if the plaintiffs had pled that they had conditioned their gift on Harvard's taking some particular action. So, for example, if the plaintiffs had said, we are prepared to give money on the condition that Harvard do X, that Harvard establish a certain kind of program, and Harvard agreed, there would be a right which would be distinct from the right of the general public to enforce the provisions of that instrument. But here there's been no such claim, and there's been no claim whatsoever that Harvard was aware of any kind of secret reservation that the plaintiffs may have had about how their money was going to be used or spent. And that represents an application of a very straightforward principle, Your Honor, of both trust law and contract law that we cite in our reply brief, both in the restatement of trusts and in a case Grover v. Grover that goes all the way back to 1833, that when a plaintiff agrees to do something or agrees to make a gift, the plaintiff can't make secret reservations or have secret reservations about the purpose to which it is going to be used. The other side has to agree. And frankly, Your Honor, that's really not much, that's a legal principle that reflects a fairly basic moral understanding that is, goes back to elementary school. It's the equivalent of saying the fact that you had your fingers crossed behind your back when you agreed to do something or agreed to make a gift doesn't give you an excuse not to do what you promised or to make the gift that you promised to make. The other thing that's worth noting about the plaintiff's claim based on the will of the donors provision of the charter is they do not merely suggest that the action which Harvard must take involves their own gift. They suggest that because they are donors, they get to effectively impose their will on, they certainly don't allege they're the only donors, on all the other donors of Harvard who may have had very different interests in focus when they gave money to Harvard, either now or over the years. Ultimately, if the court thinks about it, I would respectfully suggest that the notion that one group of donors could dictate to a charitable corporation how that public charity could spend its endowment, where there are highly likely to be multiple donors with differing interests, that it would lead to absurd results. And that is why I would respectfully suggest, Your Honor, it makes sense for the law to do what the law has done here, and to say that only the Attorney General's office, as the public's lawyer, has the right to intervene and to regulate when a public charity is purported to have violated its fiduciary duties. That's fundamentally, Your Honor, why we don't believe that the plaintiffs have successfully distinguished the climate justice case. They haven't cited to any exception to the general rule that any court has ever recognized. The will of the donors provision is must be interpreted against the long body of case law that says you can't bind someone without the other party's agreement. And because if the court were to adopt the plaintiff's position, it would effectively prevent every public charity from being able to make reasonable decisions based on its own fiduciary duties about how best to manage and spend and invest its own resources. So fundamentally on count one, Your Honor, that's Harvard's position, and I'd be happy to take any questions or move on to count two, however the court would prefer.
I want to move on to, but I want to ask one question. It sounds like you're not saying that the will of the donors clause is empty, it can mean something, but you have to have the right circumstances, namely something very close to a contractual promise. Is that fair to say?
Yes, I think that if there was an agreement that said that if I give this money to Harvard, Harvard is going to use it to this, or to any public charity, that if Harvard failed to do what it was supposed to do with it, that under the reversionary interest line of cases, there would be special standing. So in the Maffei case again, the family gave a plot of land to the Catholic Church so long as it was going to be used for a church. They allege that when the archdiocese closed the church, they were entitled to have their land back. And I would suggest the same would be true under the will of the donors clause if the plaintiffs had agreed with Harvard that that their funds were going to be used for a specific limited purpose.
Okay, and if donors started wanting to condition their donation, go to Harvard as to where to draw the line. Maybe big donations, they put all sorts of rules, they employ rules about big donations. If small donations started to ask to be restricted to certain investments and not others, they just have to decide if they want to live with it or not.
I think that's exactly right. Keeping in mind that they have an obligation that's subject to regulation by the Attorney General's office to act as prudent fiduciaries.
All right, let's talk about the second claim, false advertising under Massachusetts law.
Sure, thank you, Your Honor. I think that the first thing to observe about count 2 is that it is, in effect, an effort to get around the obstacles that are provided by Chapter 12, Section 8, the body of case law that we've been talking about. That statute addresses a circumstance where a defendant publishes an advertisement that contains an assertion, representation, or statement of fact. And that assertion, representation, or statement of fact is untrue, deceptive, or misleading. And it says that in those circumstances, on the petition of the Attorney General or of an aggrieved party, the defendant, and this is in the language of the statute, the defendant may be enjoined therefrom. That's not the relief the plaintiffs are seeking here. They aren't saying, Harvard, stop publishing advertisements that contain statements of fact that we believe are untrue, deceptive, or misleading. Instead, they invoke Chapter 266, Section 91, as a way of trying to circumvent the exclusive authority of the AG to regulate the way that public charities manage their investments. Chapter 266, Section 91, we'd submit, Your Honor, by its own terms, doesn't give the court the authority to issue an injunction for Harvard to do anything other than to, if the plaintiffs were able to establish that it had made false or misleading statements of fact, to stop making those statements of fact. But we believe, Your Honor, that in addition to that, the plaintiffs have not made out a claim on elements of Chapter 266, Section 91. The plaintiffs say they are aggrieved, and they say they are aggrieved because they are either Harvard students or hold Harvard degrees. So if we assume that that satisfies the requirement of aggrievement, there are still a number of other requirements that have to be addressed and satisfied. First of all, what Harvard, the actionable statement must be contained in an advertisement. We've addressed that in our brief, Your Honor. I won't go into that at greater length here because I know the court has read the briefs. But it must also, and I think this is the most critical point, the advertisement must relate to a statement of fact, an assertion, representation, or statement of fact that is untrue, deceptive, or misleading. So the first question is, what statement of fact, that is something under the case law that can be either proven or disproven, has Harvard made that would give rise to a cause of action here? The plaintiffs say, as I read their papers, and I'm focusing on page 30, that they believe the misleading words that were spoken by President Faust in her 2016 editorial that I believe Mr. Buffins referred to earlier in the Harvard Crimson. That in essence, that Harvard would reckon with the legacy of slavery. And pardon me, I'm having another technical difficulty here. That Harvard would reckon with the legacy of slavery. And I would suggest to the court that fundamentally, whether Harvard's promise, and this is again language from page 30 of their brief, Harvard's promise to interrogate the university's ties to slavery, and their belief that Harvard would acknowledge, understand, or reckon with their slavery and prison profiteering, that fundamentally something about the question whether Harvard has engaged in that kind of reckoning, to use the plaintiff's language, is fundamentally a question of opinion and not something that can be proved or disproved as a matter of fact. And as a consequence, Your Honor, we say that number one, the statute doesn't apply to these circumstances because the plaintiffs have failed to point to a actionable statement of fact that they've alleged is false, misleading, untrue, deceptive, or misleading. And secondly, that the relief that they are seeking in count 2 is really essentially a wolf in sheep's clothing for the relief that they're seeking in count 1, because they aren't seeking an injunction to prevent Harvard from making what they claim are misleading statements in advertising. They're using this for a purpose for which the statute was not intended, and that was to do what the long body of case law we've been discussing prevents, which is to have them as students and as donors direct how Harvard invests its endowment, and to ask the court to order Harvard to manage its endowment in the way that they see fit rather than the duly appointed fiduciaries of the institution.
All right. I do want to make sure we have time for everybody. So one other question, and I'll move on to the Attorney General's office, but the question goes back to the will of the donors clause and ties to something you were just saying at the end there. And that is, I view in their opposition papers, the plaintiffs, while they would like Harvard to divest, actually say that you can comply with the will of the donors clause by taking a serious look at the issues and reporting in some manner or another to donors. And I raise it and ask for your response just because it's it's certainly less intrusive. I'm sure it would cost time and resources, but that's a remedy they're seeking that's less intrusive than telling you how to manage your money. It's saying, show us and show the world, since you're a public charity, that your investments are consistent with, broadly speaking, the will of the donors. I understand it's a difficult project to figure out exactly what the will of donors is, but what about that alternative relief on their first claim?
I understand, Your Honor, and I appreciate the question. I do think that while that is less intrusive, I think it remains intrusive. And ultimately, the question of what the appropriate level of public reporting should be delegated to the people's lawyer, to the Attorney General, as the guardian of the public interest here. As fiduciaries, Harvard's officers have a responsibility to manage the endowment subject to the authority of the Attorney General in the way that they believe is in the best interest of the institution as a whole. The notion there have been, as the climate justice case shows, and the record in that case contained evidence of other efforts over the years by different groups to compel Harvard's fiduciaries to make investment decisions that were important to them. Ultimately, if the court becomes involved in ordering public charities to consider alternatives that the Attorney General's office has not directed them to consider, I would respectfully suggest that that gets the courts involved in the management of public charities in a way that would ultimately divert and distract them from the way that they, as the duly appointed fiduciaries of the institution, subject to the authority and regulation of the Attorney General's office, would see fit to best manage the institution. So while it is less intrusive, I think it is sufficiently intrusive that I would respectfully suggest that the court not order that.
Okay. Thank you, Mr. Murphy. We might speak to you again if some new issues come up. Let me hear from Mr. Grove from the Attorney General's office. And I might be a little more directed because I've read your brief. I think in different contexts, the Attorney General's office raised these issues, you know, in the past. I'm happy to hear whatever you'd like to say, but I'm curious about the AG's view on this will of the donors clause. I have no idea how common the will of the donors clause is on charities across the Commonwealth. But I suspect you see a lot more charity charters than I do. And so I'm wondering what the Attorney General's perspective is on what it means, if any.
Sure, thank you, Your Honor. When we look at the language as directed, the will of the donors, we really see that as a reflection of the status of the law in Massachusetts, such that charitable organizations are obligated to take and use charitable contributions pursuant to the terms in which they're given. And so generally speaking, that means that if a gift is made with certain restrictions or reversionary interests, if a charity accepts that gift, then they accept them pursuant to those terms. Otherwise, gifts made once completed are obligated to be used for the purposes of which the charity is in it. What the charity's purposes at the time that that gift was made, their general organizational purposes. And so the will of the donors language, as reflected in the Harvard Charter here, we don't see as conferring any sort of additional beneficial interest to a donor specifically. And as it relates to the allegations here in this complaint, in this matter, the plaintiffs have not alleged any additional beneficial interest as a result of their gifts, such that it would provide them standing or an exception to the exclusive standing that exists with the Attorney General's office.
Okay. You should proceed with whatever else you wanted me to do. That's my current only question. Go ahead.
Sure. I won't backtrack over the case law that has been carefully drawn out by Attorney Murphy. However, we do share the same read on the law that exists, such that donors themselves don't have a specific interest above and beyond the general public, that it would confer special standing on those donors. In these specific instances, the plaintiffs haven't alleged any other interest in their gift that would set them apart from all the other donors to Harvard, despite their reference to the charter. Although we as an office appreciate the really important questions that are being raised by these plaintiffs, and we share an interest in the work that they're doing to ask Harvard and all charitable institutions to address the realities of systemic racism. Ultimately, this is an inappropriate forum for that kind of advocacy, and their claims as made in this complaint are insufficient to confer special standing upon them to pursue this type of relief. And that's why we moved to dismiss this count based on that jurisdictional law in the Commonwealth.
All right. So I've heard from both Attorney Murphy and you that the will of the donors clause can mean something in the right circumstances, namely when up at the front end of the donation, there's been a agreement on specific uses, specific terms, that type of thing. But the plaintiffs also point to this idea that at some point, use of donated money could be so contrary to the charitable mission that you don't need those terms up front, but instead, it's just a broader view. Now, I understand the Attorney General's position is, even in that event, it would still be your claim to bring and not the individual donor unless they establish the terms up front. But is it conceivable that investments or other use of money could be so contradictory to the charitable mission that the AG could get involved? But that would be up to you and your, elected official discretion.
It's certainly within the discretion of our office to investigate and pursue that type of an action in circumstances where there are allegations that the use of an investment is so contrary to the fiduciary duty owed to the pursuit of a charitable mission. As we were presented with the case in this circumstance, we're looking at the claims as they sit in the original complaint, and here felt it necessary to protect that discretion with the Attorney General's office. And it's for those reasons that we moved to dismiss this first count.
Okay. And then to take it out of the realm of hypothetical, if it's even possible, has that ever happened? The notion that the use of charitable donated money was so contrary to the mission that the AG's office stepped in, whether it's an investment context or something more direct?
I don't know that I can direct you to a specific case off the top of my head that parallels the allegations in this complaint, but it is entirely within the realm of the work that we do day in and day out, looking at how charitable organizations are meeting their fiduciary obligations and pursuing their missions.
Okay. Anything else from the AG's office?
Nothing else.
All right, I may come back to you with some questions, but why don't we go to the plaintiffs? Let me ask how you'd like to proceed, whether there's certain people covering certain topics, or you tell me.
Yes, Your Honor.
Oh, okay.
This is Amanda Chan. I will be arguing count 1 on behalf of the plaintiffs today, and my co-plaintiff, Anna Nathanson, will be arguing count 2 with the permission of all of the co-plaintiffs.
Great, that sounds fine. I would like to hear about count 1 first, so I think that's you, Ms. Chan.
Yes, thank you, Your Honor. I think I'm going to address the points that Mr. Murphy and Ms. Gabro made one by one, and then if time allows, I will go to the argument that I had previously prepared.
Okay.
So, pointing to your request that we address the extinguishment of fossil fuel from our case right now. Fossil fuel brought 2 counts. The first was essentially a breach of fiduciary duty, and the second was endangering future generations. We don't bring anything alike count 2. And with regards to count 1, although a lot of the language we use to describe the breach, we are not, may seem similar to a fiduciary breach, we are not bringing a fiduciary breach whatsoever. We're actually bringing a contractual claim. So any allegations that our private interests, our private claims are in the world of fiduciary breaches are not true. And we readily admit that the Attorney General has complete jurisdiction over fiduciary breaches. What we're actually focusing on is the meaning of the will of the donor's provision. Specifically, basically the divide seems to be one side, the defendants say that this provision means nothing, while the plaintiffs assert that it means something, but I will get to that later. So Mr. Murphy points out that there's a few types of cases that have allowed previously plaintiffs to assert special interest standing against public corporations. And plaintiffs have aligned ourselves with more of he refers to it as the voting rights types of case law. And he says that donors do not have special interest standing even in Massachusetts. And he points to Dillaway, Ames, and Garland. What is important to emphasize about these cases is that these cases are about donors bringing fiduciary breaches in the public interest. Now, What happens when plaintiffs who are named beneficiaries in a contract bring contractual rights in the court? That is a completely different question from the Dillaway, Ames, and Garland cases. Now, Mr. Marty also says that it would be different if we had conditioned the gift and Harvard had agreed to those conditions before we made the donation. So essentially the argument he is making is that the provision of the will of the donors refers to the common law Massachusetts gift restriction rule, if you will. What the issue here is that defendant Harvard would be required to follow the gift restriction rule, whether or not the will of the donor's provision exists in the charter. So according to Hosmer, which is a Supreme Judicial Court case, also almost 100 years old, every single clause in a charter must be given meaning and effect. It must mean something, essentially. So if we were to go with defendant Harvard's interpretation, it would mean that that clause has no meaning. That's in violation of fundamental principles of contract. That's in violation of Hosmer.
So I agree it needs to mean something. And I think I have in mind two different potential meanings. The first one, you heard Harvard focus on, and that is, you have to strike a deal up front. You have to determine the terms up front. I don't think you're claiming that one. Is that fair to say?
That's correct, Your Honor.
That's why I want to see if you paint it differently than what's on my mind. What I have in my mind as the broader contract right that you're asserting is that even though we didn't strike terms at the outset of our donation, certain uses of donations are so contradictory to the mission that they're, you just candidly said it's really about breach of contract, that they violated our agreement. And am I characterizing the claim correctly, or would you put it a different way?
Actually, Your Honor, while that is also certainly a valid interpretation of the will of the donor's provision, the will of our interpretation that plaintiffs assert is more specific to the circumstances in which the charter was written and the circumstances in which the contract was readopted in the 1970s. So I'm going back to Hosmer again, which says that the interpretation of a contract may be qualified by the context in which it appears and by the circumstances existing at the time the contract was executed. So when we talk about circumstances, we're talking about the historical and traditional up until all the way up to the 2000s behavior that Harvard has been engaging in with different donors. We put forth the example of Abbott Lawrence, who gave money, a large amount of slave money to the university, and was very actively involved in the implementation of that donation long after the donation had already taken place. This is true with more recent examples as well, which we would be happy to submit supplemental briefing on. But for example, the affirmative action litigation has revealed that even after parents have donated large sums of money to defendant Harvard, there's no gift instrument saying that if I give you $1 million, you have to let my kid into Harvard. But yet that is the behavior that Harvard is engaging in. So really what we're pointing to is defendant Harvard's own behavior and how that fills and colors the provision of the will of the donors.
Well, let me just flesh that out. So you're saying that since Harvard was saying in the neighborhood of 2016 and since then that we care about and intend to do something about our connection to slavery, that built into the donations around that time or since are that promise? Is that what you're saying?
No, Your Honor. The promise regarding President Drew Faust's promise regarding the promise to address slavery speaks more to count two. My count one, it's less about slavery and more about the relationship between Harvard and its donors when the contract was written and throughout time, how defendant Harvard, through its actions, have interpreted the will of the donor's provision.
All right, so then, if it's a contract approach, what is it about Harvard's investment that breached the contract that you're asserting?
Exactly, Your Honor. So what I'm pointing to is that traditionally donors, big time donors, have been able to have some sort of say, a seat at the table, if you will, an open ear and a degree of deference after their donation has already taken place. And I'm saying that was true back in the 1600s, and I'm saying that that's true up until very recently. So Mr. Murphy and you discussed this issue of intrusiveness. If it's purely an analysis of intrusiveness, I mean, it could be as simple as a vote. I mean, publicly traded corporations engage in shareholder proxy votes all the time. It's not a huge burden. And especially for defendant Harvard, it's not a burden who literally every year reaches out to all of their alumni in existence for the Board of Overseers elections. So if it's in terms of administrative burden, they already have the infrastructure in place when it comes to reaching out to alumni and getting us something as simple as a vote. The issue here is, must defendant Harvard, after donations have already taken place, just listen in good faith, according to the provision of the will of the donors in the Harvard Charter. Now, Mr. Murphy also referenced that this would be bad for all public charities. But because our claim is so deeply rooted in this specific provision of the Harvard Charter, unless it is also present in other public charities en masse, it really wouldn't be a persistent problem outside of the sphere of Harvard.
All right, thank you. Now I do understand your approach to it. And let's say I agree, and that the will of the donors clause requires at least listening to every donor in good faith, large or small. The challenge then gets to, after all the listening, and let's presume it's good faith listening, after all the good faith listening, sooner or later, institutions make decisions. So, I mean, you know better than I the history between the plaintiffs and the Harvard defendants, but I think one could argue that just sitting down and listening, does that satisfy your standard, or do they have to agree with you? Because you could have not just one or two meetings, you could have 20 meetings, and at the end, if Harvard said, you guys are very thoughtful, we appreciate it, it's been great listening to you, and our decision is to not divest from prison industry. Could that conceivably be in good faith?
Absolutely, Your Honor, absolutely. This is a procedural claim that we are advancing. Any allegations that we want to control the outcome, control the minutia, dictate the investments is not true. What we're really asking for is to be heard in good faith, and that's what we've been asking for in our briefings since early on. Now, for example, if there was the vote, if 99% of the alumni, if this vote were to happen, voted that we want to divest from private prisons or the prison industrial complex more largely, but defendant Harvard, who is obligated to both juggle its fiduciary duty and its contractual obligations, decides that in the interest of ensuring Harvard's existence in the long term, and in the interest of ensuring that Harvard's returns on the endowment are steady and up in the long term, that they're going to remain invested in legal slavery. They're going to remain invested and profiting from the backs of the mass incarceration of Black people, then so be it. That is the extent of the legal claim. Now, of course, I want divestment, but that's something that I would have to advocate for outside of the courtroom. Here, we put the information in front of them. We ask for a vote or whatever provision, whatever method defendant Harvard chooses to use, and that's all we can ask for as per the provision of the will of the donors.
Okay, thank you. I understand that much better now than I did coming in. How about even, I actually think it would, I'm guessing it would be within Harvard's current, discretion if they wanted to include in their annual Board of Overseers election form a few questions. Would you like us to divest generally speaking, head towards divesting from fossil fuels, head towards divesting from anything to do with prisons. But how do they even know what questions to ask? Where does that come from? Is that also the will of the donors clause? Or is it just their, decision to try to be a good charitable citizen?
Well, Your Honor, whenever a donor makes a donation to Defendant Harvard has all their contact information on file. If a donor wants to be heard, as plaintiff donors had wanted to be heard, we can easily contact Defendant Harvard and ask for whatever mechanism they choose to implement. Now, I will say that we did meet with Defendant Harvard, but I actually don't believe that that's the precedent that Defendant Harvard wants to set. I mean, it would be probably an administrative burden to have to meet with every single small-time donor to listen about their woes or demands about the endowment, which is why I personally think that if I were Defendant Harvard, I would make my life a lot easier by using the infrastructure already in place, as you noted.
All right. So let's keep in mind, the question is whether they're obligated to do it rather than whether it's a good response to groups like yours or any other group.
I'm sorry, could you say that again, please?
I said, let's keep in mind, the question is whether they're obligated to do it rather than just, it might be a nice thing to do in response to any donor or groups like yours that get together.
Yes, Your Honor, and our position is that Defendant Harvard is absolutely obligated to do it. That was true because that is true. It was written in the charter in 1650, and because it was readopted by some of the same people, the Harvard Corporation, in the 1970s. Now, the Harvard Corporation wanted to summon up another meeting to amend the charter. That'd be one question, but another question. But as of right now, that will of the donor provision is there. And again, we assert that it must mean something. It must be in accordance with Hosmer and the Supreme Judicial Court's precedent, as opposed to a reference to a rule that may or may not have been in existence at the time of the charter's execution.
Okay. I do want to hear on count 2, but I'll give you a chance to tell me anything you haven't already discussed.
Thank you, Your Honor. I just wanted to say that today, plaintiff donors are here to ask Defendant Harvard to fulfill its obligation to do what it is contractually required to do. Give Harvard donors a seat at the table, be it a meeting, be it a vote, via the already existing infrastructure. Harvard is fully within its rights to invest in lawful slavery if that is what its fiduciary judgment ultimately decides. But at the very minimum, Harvard must also hear plaintiff donors' moral and financial concerns in good faith. Defendant Harvard knowingly and intelligently chooses to enter into this contractual relationship with all these small-time donors. As such, Defendant Harvard must be required to be upheld to those contractual obligations, which I might add is a field, contracts, that courts have long presided over. Thank you.
All right, thank you. Ms. Nathanson on count 2.
May it please the court. We respectfully ask this court to deny the motion to dismiss in regards to count 2, the false advertising claim, because plaintiff's false advertising claim is sufficient. There are 4 reasons this is true that track Mr. Murphy's arguments. I will give an overview of the issue, then discuss each of these reasons in turn. I will first note that this is a completely distinct legal argument from count 1 and can rise and fall without it, and it's a matter of Massachusetts false advertising law. Your Honor, Harvard's president, in her official capacity in public-facing promotional materials, advertised that Harvard would undermine Harvard's legacy of slavery. But Harvard is still invested in present-day slavery, the prison industrial complex. If universities are allowed to publicly proclaim they will engage in anti-racist and anti-slavery programming, and then directly violate those commitments, and there is no accountability for it, it means consumers of higher education will be lied to, taken advantage of, with no remedy. It would undermine any faith we consumers could ever have in these institutions, especially for the most marginalized groups of Massachusetts. That is what is at stake here today. This claim involves an undecided application of Massachusetts General Law, Chapter 266, Section 91. So it is a case of first impression, and the court must make an original ruling on the issue. But Harvard has committed the type of false advertisement that Massachusetts state law offers its protection against. One tool this court can use in rendering its decision is the Lanham Act, which offers state courts a floor, but not a ceiling, for understanding what constitutes an unlawfully false advertisement. The language of Section 91 lays out expanded protections against false advertising compared to the federal Lanham Act. The court must consider the relevant differences between state law and federal law, and specifically apply state law where appropriate. Turning to our first reason, Harvard made an assertion, representation, or statement of fact which is untrue, deceptive, or misleading under Section 91. First, I'll explain how you should interpret Section 91, and then I'll move to what the misleading statements here are. Harvard claims that we should toe strictly to the federal case law about what the Lanham Act phrase statement of fact means. We disagree. However, even if you accept their standard, Harvard made a statement of fact. As defendant Harvard emphasizes, the key quality of statement of fact is that such statements can be proven false. That a statement may implicate opinion does not vitiate the statement's ability to be made false by some conditions. See the Chobani case. The correct standard, however, is laid out in Massachusetts law. It's a broader category of statements which are actionable under the Massachusetts false advertising statute. Not just false statements of fact, but assertions, representation, or statements of fact which are untrue, deceptive, or misleading. A plain reading of the statute suggests that an assertion, representation, or statement of fact is something that has been communicated which can be shown to be untrue, deceptive, or misleading. This broader interpretation would be in line with other Massachusetts state law definitions of false advertisement. In the Code of Massachusetts Regulations, 940, Section 3.02, the Attorney General defines false advertising as a statement that misrepresents the product in such a manner that later on, disclosure of the true facts, there's a likelihood that the buyer may be switched from the advertised product to another. A misrepresentation significant enough that it might influence the consumer is enough to qualify as false advertising. The court should apply a Massachusetts-specific definition to Section 91, either by using the Attorney General's regulation or by creating its own. Now let's look at what the misleading statements in this matter are. There are two principal misleading statements. They are both in the Harvard and Slavery Statement, Exhibit J. Number one, Harvard stated that Harvard continued to be indirectly involved in the American system of racial bondage through extensive financial and other ties to the slave South up to the time of emancipation. This is misleading because it claims that Harvard is no longer financially tied to the institution of slavery. This is proven false when Harvard continues to invest in slavery. Second, also in the Harvard and Slavery Statement, Harvard stated that Harvard must do its part to undermine the legacies of race and slavery. Harvard promised to undermine its legacy of slavery. Again, this is proven false when Harvard continues to profit from slavery. Harvard is perpetuating, benefiting from, and expanding slavery. Furthermore, a Harvard historian hired to work on the Harvard and Slavery Project has come forward as a whistleblower to expose the Harvard and Slavery Project as a sham. From the beginning, it was underfunded and under-resourced. It required the historian to keep the research about Harvard and slavery proprietary, so it could be kept private and never released to the public. That's in our complaint, page 12 through 13. It ignored a descendant of enslaved people, Tamar Lanier, when she came forward to retrieve her ancestor's photo, page 13 through 14. Through the discovery process, we would be able to flesh out the extent of this sham. Harvard undermined their Harvard and Slavery Project. Harvard is not trying to undermine its legacy of slavery. Now let's turn to our second reason. Defendant Harvard statements were advertisements because they were public and proclaimed to the point of view of their product. We asked the court to stick closely and narrowly to the Smart Foods decision, where the court ruled that advertising means a public announcement to proclaim the qualities of a product or point of view. By defendant Harvard's own admission, President Faust's statement was publicly announced to proclaim Harvard's point of view. See Harvard's motion to dismiss, page 14. The statement conveyed that Harvard had the quality of being an institution that properly addresses the legacy of slavery. Turning to our third reason, plaintiffs meet the injury requirement for cases seeking injunctive relief only. Defendant Harvard incorrectly asserts a specific injury requirement stemming from Lanham Act cases for money damages. We are seeking injunctive relief only. Plaintiffs who seek only injunctive relief need not show actual harm or specific injury. These plaintiffs must demonstrate only that the defendant's activities are likely to cause confusion or deceive customers. See Spruce Environmental Text. As previously explained, defendant Harvard's claims are deceptive, so would likely deceive or confuse customers, students, and donors, and thus meet the Lanham Act injury requirement. We also have alleged an injury as students who remained enrolled at a university and expended years, labor, and energy at an institution that profits from slavery in prison, despite President Faust's statements to the contrary. Plaintiffs suffer from the reliance on defendant Harvard's false statements. This has been emotionally devastating for plaintiffs. Turning to our fourth reason, Harvard acted with intent to advertise because it widely disseminated its statement. Under Massachusetts law, a business's wide dissemination of information signals intent to advertise. See Smart Foods. Here, defendant Harvard published President Faust's statement on their website and in the Harvard Crimson. Harvard likes to emphasize the Crimson part, but to be clear, this was on their website. The president purposely published her statement in venues where she could reasonably expect prospective Harvard students and donors would see them. The Harvard website is also where Harvard hosts admissions information and its donations portal. If you look to Exhibit J, you'll see that right above the Harvard and slavery statement, there are links to admissions and other places where people can buy or interact with the Harvard brand. Defendant Harvard statements have clear commercial purposes for Harvard. Plaintiffs reasonably infer that by issuing assurances that Harvard would grapple with its historical involvement with slavery, defendant Harvard aimed to attract students, and particularly Black students, to apply to Harvard. Public pronouncements such as President Faust's Harvard and slavery statement contribute to Harvard's reputation, which boosts its admission numbers, its rejection rate, its selectivity, and increased donations from alumni. The discovery process would allow us to further clarify Harvard officials' commercial intent for these statements. The intent requirement is met.
Let me, when you categorize the statements that are the thrust of your false advertising claim, you mentioned the statement that Harvard was continue to be involved in slavery until emancipation, and then they promised to undermine their past participation in slavery. It seems to me the linchpin is for me to read the statement slavery as including the current day so-called prison industrial complex, generally speaking. Is that fair?
That is correct, and Your Honor should rule that way under two separate reasonings. First, the court should find that prisons are slavery as a matter of law under the 13th Amendment. Alternatively, at trial, this should be treated as a question of fact that plaintiffs are prepared to prove to the jury.
So I understand, I understand the theory. There's a historical continuum that you would trace from when slavery officially ended through today, where there's still, data indicating racism in prison populations and all that. I understand the theory, but I feel like you're asking me to substitute in Dean Faust's statement the word structural racism for the word slavery. And at least it seems to be a matter of opinion or differing views whether slavery actually is current day, so-called prison industrial complex. I think when we're in the world of false advertising, the actual terms are pretty important. And so I feel like you're suggesting when she said slavery, I should really read that to mean structural racism that we're going to get involved with and make sure we have, unwound. That's my impression. You tell me why you're not asking me to read it that way.
So what's important for a false advertisement is does it mislead consumers? How would consumers interpret this? If Harvard wanted to advertise itself as only addressing the legacy of legal slavery, it could have said that. It could have said, we support child slavery, we support prison slavery, we're only addressing our history of slavery. But they didn't do that, and they have to be held to that. Additionally, we think it's a matter of federal law that the condition within prisons is slavery. We had submitted a reply that we're happy to resubmit as a supplemental briefing with federal case law explaining that, in which the court has ruled that involuntary servitude in prisons is a polite word for slavery.
No, I read this reply. I understand yours. Okay. Anything else on false advertising?
In summation, Harvard made a public statement. This statement must be made true, or Harvard unjustly enriches itself and undermines any faith we could have in it as an institution. This discovery process would allow us to further clarify the bad faith operation of the Harvard and Slavery Initiative and officials' commercial intent for these statements. It would allow us to flesh out how consumers thought these statements applied to prison slavery. For these reasons, the court must deny the motion to dismiss in regards to count 2 and allow the case to proceed to obtain a fuller record before this case is decided on the merits. Thank you.
All right. Thank you. I think I have the information I need to take the matter under advisement and get to a decision. It might take me a little while, but I'll try to be prompt. But before I adjourn, if they promise to keep it short, I'll allow the moving parties a short response if they would like. Mr. Murphy, anything to add? Mr. Murphy, you got to unmute.
Thank you, Your Honor. Your Honor, I would only ask the court, as it is considering whether to dismiss this complaint, to turn its attention to the prayers for relief, because I think what's happened here today is the discussion has evolved from the prayers for relief that are set out in paragraphs 101 through 108 of the complaint into a discussion about what the plaintiffs think that Harvard ought to do to address the issue, which Harvard has, in its view, addressed. And ultimately, the question here is who decides. And I would respectfully suggest to the court that under Massachusetts law, absent some special interest of the kind that we've been discussing here today, which the Attorney General and we agree the plaintiffs do not have, subject to the regulation of the Attorney General and the oversight of the Attorney General, how Harvard addresses these issues and how any public charity addresses these issues must be left in the first instance to the discretion of the duly appointed fiduciary. So I think the question here is who decides, and I think under the case law that is clear. I would ask the court with respect to count 2 to consider 2 items, Your Honor. Number 1, again, to examine the prayer for relief that's requested. The plaintiffs, the statute allows a court to issue an injunction to stop misleading and deceptive statements of fact. That's not the relief the plaintiff's seeking here. In addition, Your Honor, I think if the court looks at Exhibit J, the exhibit that the plaintiffs have cited, you will see that what President Faust, who is after all a scholar of American Civil War history, is talking about the historic slavery in the South. As she says, the importance of slavery in early New England was long ignored even by historians. The Harvard was directly complicit in America's system of racial bondage from college's earliest days in the 17th century until slavery in Massachusetts ended in 1783. I think it is very clear in context what she's speaking of, and that is the system of slavery that existed at the time of the Civil War and the time that leading up to the Emancipation Proclamation. And I don't think there's grounds for there to be any false statement of fact in anything that she said there. I don't think there's any likelihood that there's any false statement of anything there, but certainly whatever is said there is not with respect to the issues that the plaintiffs are describing, a statement of that can be either proven or disproven by evidence in the way that the false advertising statute is intended to reach.
Okay. Thank you. Ms. Cabral, anything for the Commonwealth?
Just one thing, Your Honor. While the plaintiffs here have attempted to distinguish their claim in regards to will of the donors from a fiduciary duty claim, I think it's important to point out that the ask that they're making in this claim is with regard to the entire endowment and not a specific contractual claim as to their individual donations. And what that presents to the office is a concern regarding opening a door to exactly the type of potentially overburdensome litigation that the exclusive standing doctrine is designed to protect against. And so we'd ask Your Honor to consider the fact that this doctrine is put in place for a purpose, supported by a century of common law and important public policy, and that the obligation and the opportunity to protect these types of interests remains within the Attorney General's office.
All right. Thank you. I want to thank everybody. We'll take the matter under advisement.
Are we maybe respond to that?
60 seconds. Go right ahead.
So first, I would like to note, I think it would be highly irregular to dismiss a sufficient complaint simply because you disagree with the remedies the plaintiffs suggest. Additionally, we have asked for these specific remedies for a reason. We relied on what we now realize were misrepresentations made by Harvard in its advertisements. We relied on these when we entered the university. Since we have now invested time and academic effort that cannot be undone, and there is no adequate remedy at law, the equitable remedy of the injunction is the only practical and reasonable relief available. And there's no other choice. This is an extraordinary situation. Anyone who is not able to see that prisons are slavery will be a fool of history, and we're prepared to flesh that out through discovery and trial. Thank you, Your Honor.
All right. Thank you. So I'll take the matter under advisement and write a decision, and I'll do my best to do that promptly. And so thanks everyone for your presentation. Before we adjourn, I just have to ask Ms. Chan what that is I'm looking at in the background. We do a lot of Zoom hearings these days, and I'm curious what your background is behind you in the scene there.
My background is Zoom backgrounds for lawyers from Google Images. I highly recommend.
I was just curious if it was a particular, state Supreme Court or something. That's all. All right. I'll go on Google and figure it out. Thank you all very much, and I'll get your decision soon.
Thank you.
Thank you, Your Honor.